Thank you everyone for being here today. My name is Melina De Bona and I'm an attorney at the Earth Rights Research and Action Terra program at NYU Law and also an adjunct professor at the Terra Clinic. My work, among other things, centers on the right to a healthy environment. We're here today because 3 years ago, the UN Human Rights Council adopted a historic resolution recognizing, for the first time at the global level, the human right to a clean, healthy, and sustainable environment. This provided momentum for the General Assembly to adopt a similar resolution with overwhelming support in 2022. Now, although the UN recognition is recent, the right to a healthy environment is not a new right. The right and associated obligations have deep roots in many indigenous and more recently in Western legal systems. Today, the right enjoys legal protection in 164 nations through constitutions, legislation, regional treaties, and also court decisions. Now, as with any human right, courts play a critical role in defining its parameters, the scope, and its application. To illustrate the power of judicial action, David, César, and myself thought that it would be opportune to write and launch a report highlighting the 20 landmark right to healthy environment decisions drawn from every region of the world. To do this, we reviewed court decisions on the right to healthy environment from more than 70 nations and curated a set that we believe showcases some of the most impactful decisions, both positive and negative, regarding the right. Please note that you may find the report on Terra's website, which is called the Right to Healthy Environment Toolkit, which has been provided in the link in the chat. The R2HE Toolkit, created in collaboration with the UN Environment Program, is a first database to map the legal recognition of the right and to also analyze significant right to healthy environment case law and developments. So today, we'll be having a conversation with some of the world's leading experts on the right. In doing so, we will both provide an overview of some of the key trends regarding the right, and trends are becoming increasingly relevant, as well as the hurdles and opportunities that the right faces. We will do so while gaining insight about a number of the cases featured in the report, but we of course invite you to read the report in full. I also would like to thank the support of our lovely research assistants, Emma and Anne, who were key in the research and the publishing of the report. So without further ado, I will introduce the panelists today. First, we have David Boyd. David is the former UN Special Rapporteur on the human right to clean, healthy, and sustainable environment, who served his mandate from 2018 to 2024. He's also professor of law, policy, and sustainability at the University of British Columbia. As a fun fact, he's also a triathlon world record holder. And appropriately, David has passed on the baton to Ms. Astrid Puentes Riaño. Astrid is a current special rapporteur on the right. She teaches at Berta Cáceres Environmental Justice Clinic at the Universidad Iberoamericana in Mexico City, and has more than 20 years of experience on environmental law, human rights, and climate change, as well as intersection of these, with a perspective of climate justice, diversity, equity, and inclusion. Then we have César Rodríguez-Garavito. He's a professor of clinical law and the chair of the Center for Human Rights and Global Justice at NYU School of Law. He's a founding director of Terra, which I am a part of, the More Than Human Rights Moth program, the Climate Law Accelerator, and the Future of Rights and Governance Forge program at NYU Law. Professor Garavito is a field lawyer and an earth rights and human rights scholar whose work focuses on climate change, international environmental law, indigenous people's rights, and the more than human rights. And last but not least is Michelle Jonker-Argueta. Michelle is a senior legal counsel and oversees Greenpeace International strategic litigation work. Michelle advises on the development and implementation of legal strategies to hold governments and corporations accountable for climate change and biodiversity loss, as well as human rights implications. Now, on a personal note, I will say that I have and am working with all of these individuals in some form or shape, and I think it's a privilege to have them all together in this room to talk about the right to healthy environment. So with that, we will get started. So the first question goes to David. So David, given your expertise as the UN Special Rapporteur from 2018 to 2024, could you share your insights on how jurisprudence, specifically the 20 landmark cases we're discussing today, has shaped the substantive and the procedural elements of the right to healthy environment? In other words, where do we currently stand in this evolution? And could you provide 2 to 3 example cases that have notably expanded or solidified the rights content and scope?
Yeah, thank you very much, Melina. It's a real pleasure to be here with some of my favorite human rights and environmental lawyers from around the world, including yourself, Astrid, Michelle, and César. So thank you for this opportunity. And what was really fun about this report, I mean, we say fun, it was just amazing to be reading through these court decisions from over 70 countries. We reviewed hundreds of decisions from Kenya, South Africa, India, the Philippines, Latvia, Portugal, the United States, really every region of the world. And there are just some very striking developments. The courts around the world have clarified the content of the right to a clean, healthy, and sustainable environment, that it comprises a group of procedural elements and a group of substantive elements. The procedural elements include access to environmental information, public participation in decision-making, and access to justice with effective remedies. And on the substantive side, courts have been very clear that the right to a healthy environment includes clean air to breathe, safe and sufficient water and adequate sanitation, healthy and sustainably produced food, non-toxic environments where people can live, work, learn, and play, healthy ecosystems and biodiversity, and a safe, livable climate. And so we've chosen 20 of the leading judgments from around the world that really illustrate these substantive and procedural elements. So for example, we have highlighted cases from Mpumalanga, a very polluted city and region in South Africa, where 2 environmental justice organizations took their government to court, arguing that the failure to improve air quality violated their constitutional right to a healthy environment. And the court made a very powerful decision in which it found a violation of the right to a healthy environment and ordered the government to take clear steps within certain timelines to improve air quality in the Mpumalanga region. And that case is part of a series of cases worldwide that courts have emphasized the importance of clean air in a world where polluted air is killing more than 7 million people every year. And as well as clarifying the procedural and substantive elements of the right to a healthy environment, of course, courts are also clarifying the associated state obligations. So if we look at air quality, for example, courts have said very clearly in South Africa, in Indonesia, in Peru, and around the world that governments must enact legislation, regulations, standards, and policies to improve air quality. They must monitor air quality and inform the public about levels of air pollution. And they must come up with action plans that target the most important sources of air pollution. And finally, they must enforce measures to ensure that air quality standards are being met. So that's very clear guidance for governments to take. And it's also very powerful that citizens and organizations can hold governments accountable for not taking those steps. We've also seen courts around the world clarifying that a safe, livable climate is a fundamental piece of the right to a healthy environment. So in the United States, for example, we have state-level courts in Hawaii and Montana that have said in crystal clear terms that the right to a safe, livable climate is part of the right to a healthy environment. And the right to a healthy environment has also been used to protect ecosystems and biodiversity, which some of my colleagues will talk about in more detail. But effectively, courts have said around the world, states must protect endangered species and endangered ecosystems, from hammerhead sharks in Costa Rica to wolves in Portugal, from cloud forests in Ecuador to mangroves in Mexico. And so we're really getting clarity around the content of the right to a healthy environment and the associated obligations. And so there are still a handful of states around the world, including the United Kingdom and the United States, that internationally say, well, we're not sure what the right to a healthy environment really means. We're not sure about its content. And those statements can now be completely and forcefully rejected We know what the right to a healthy environment means, and the key now is to move forward with implementing it and fulfilling it for each and every person on this planet. Thank you.
Thank you, David, for that very powerful introduction. And I think it is indeed very exciting that we're seeing courts affirm more and more and clarify the boundaries of the right and what that means for states and corporations. So looking a little closer at an example, I'll turn to Astrid. Astrid, I would like to ask you about a case that reflects the culmination of several trends related to the right to a healthy environment. In Community of La Oroya versus Peru, handed down by the Inter-American Court of Human Rights just some months ago, which you worked on for many years, we can see a truly landmark case. This is a case in which a regional court concluded that the right to a healthy environment and other human rights were violated by Peru for more than a century of disastrous industrial pollution. The court's decision is the strongest and most comprehensive judgment on the right of any regional human rights court to date. So could you tell us more about the court's ruling, and in doing so, what the ruling reflects regarding court's current understanding of the right, with the caveat, of course, as we have seen from our analysis, that the Latin American and the Caribbean region represents a relatively progressive perspective.
Thank you very much, Melina. And it's for me an honor to share this space with all of you. And yeah, we have worked together separately in a lot of things, but it's really great to be in this space together. And in a lot of ways, La Oroya tells the story of Latin America. I mean, today we see the decision that is an amazing, as you described, Melina. It's really a very good decision that the court advances a lot of standards. And one of the things that I also want to remind ourselves is a litigation that took almost 20 years. And that before that, there was the community still working to make sure that this, first of all, that the issue had attention, and then worked a lot to make sure that both the courts nationally gave them some justice. So one of the things that happened is that the community in La Oroya started working on this, and they had in 2006 a decision from the Constitutional Court in their favor that is still pending. And so it tells us that, of course, as we know, litigation doesn't happen in a vacuum, and that while judges and the role of judges is absolutely essential, these litigations also have behind and around the work of movements and organizations that insisted and brings these cases to court so that we can have this clarity and the decisions that today we are analyzing. It was a very long case, and one of the human rights that actually was violated and the court concluded is actually the right to access to justice. But it only in the inter-American system, it took almost 20 years. So I think that that is something that is important also to have in mind. How do we, can we have actual justice and these decisions faster? Because while we have this very important finally conclusion, it took way too long, both in the Peruvian system and also in the inter-American system to get to here. Then the other aspect that I want to highlight also is how important it is to look at implementation, because today, unfortunately, Peru is facing big challenges in their systems. And so making sure that this decision is not only rendered, but implemented is also very important. A few other things that I want to highlight about this case that today, of course, we celebrate is that when AIDA, that I had the honor to start working with a lot of time ago, 20 years ago, and Peruvian organizations, when they started working in this, is because the community called for help. But it was at the end of the 90s and in the 2000s, sorry, but it was considered a lost cause because the situation was already going on for a few years. And La Oroya and the decision at the end, but also shows the importance of the continued and insisting of environmental justice that unfortunately is very difficult to achieve, but also shows the inequalities and the systemic discrimination that people and most marginalized people is facing. There are many firsts in La Oroya at the inter-American system, and I literally will just enumerate it because it will take, and maybe we can do a webinar about La Oroya and invite the people that litigated that and the community that worked on it to talk in depth about it. Yeah, so the first one, as you mentioned, is the first case that talks about air pollution. As we know, it's an essential element, as David mentioned, of the right to a healthy environment. It's also the first case that talks about environmental impact on an urban population as opposed to indigenous peoples, because all of the cases before in the Inter-American system regarding environmental pollution included and were around indigenous rights. But this is the first case about an urban pollution. And this is key because 80% of population in Latin America and the majority of population in the world, we live in cities. And so the reminder that environmental rights is also a matter of cities. It also touches industrial pollution and talks about sacrifice zone, that this is something that David worked very hard, and Marcos Orellana, a colleague, rapporteur. It also highlights the differentiated impacts that contamination can have in human rights. And for years, for decades really, the people that were litigating and the people in La Oroya highlighted that it was not only about human rights, but it was a differentiated and thus a discrimination evidenced because of the vulnerability of children, women, and the elderly. And the court understood this and highlighted, and this is one of the key aspects that we have in the decision. The other one is that in La Oroya, the exhaustion of domestic remedies was done through a collective legal action, which is also a first. And as a litigator of the case, this was one of the things that we were very worried about, because it's about the merits, right? And it's the first time that a collective action exhausts national remedies to take a case in the Inter-American system, which opens the possibility, because a lot of the litigation or legal actions that we have in Latin America are collective actions regarding the protection of the environment. It also recognizes the state's responsibility of the death of 2 people that was linked to the contamination. Unfortunately, people that were part of the petitioners died throughout the process. And the court recognized that their death was linked to the contamination and thus the responsibility of the state. It also touches procedural elements, both the importance of public participation, access to information as a human right linked to environment, and it reminds also the decision from Claude Reyes and access to justice. And the last element that I want to highlight that is also very important is that the court recognized that there was the state responsibility because of a risk that the state created. And this is very important, and it's an advance on international law standards based also on jurisprudence from the European Court, where the Inter-American Court concluded that Peru was internationally responsible because it was fully proved that the contamination posed a significant risk to people's health and that people were exposed to this risk. And the third element is that the state was responsible for the lack of prevention of the risk. And the conclusion in this case is that the court agreed with the petitioners that the court didn't request a direct cause or the proof of the direct cause between the alleged illnesses and the contamination to prove the responsibility. And so that is a very big change of the burden of proof in these kinds of cases. And I will just stop there and thank you very much.
Thank you, Astrid. Yes, as you mentioned, this is such an important case that honestly brings together so many of the dimensions of procedural and the substantive dimensions of the right to health environment in a way that's really attempting to create change for people. And I do encourage, by the way, everyone in the audience to write any questions that you may have for our panelists that we'll get to by the end on the Q&A chat. But for now, we'll move on to another aspect of the right to healthy environment, which I think is also up and coming. So moving on to César, as David highlighted, César, the right to healthy environment represents a powerful right in that it can incorporate, and it does incorporate, a broad array of substantive elements and procedural elements that capture the real world implications of our triple planetary crisis, that is of climate, biodiversity, and pollution, and probably will be a growing planetary crisis in that sense. So César, I'd like to delve into the interplay of some of these elements. Specifically, let's explore the connection between climate and biodiversity as an example. How effectively is this relationship acknowledged in legal frameworks? Are there cases that have recognized this interplay? And furthermore, what do you see the role of the right to healthy environment to be in this context?
Thank you, Melina, and it's a great pleasure to be with my fellow panelists in this event and with everyone in the Zoom room. It was really a joy to write this report with David and Melina, and with the support of our great students, Emma Crow and Anne Pfeffenberg, partly because most of the effort was on how to make sure that we did justice to the complexity of the cases and at the same time wrote the narrative in accessible terms. So if we succeeded at making these cases, which sometimes are arcane or very long, 100 pages, some of them accessible to a wider audience and to a wide audience of scholars and researchers, then we would be thrilled to have brought this report to the world. And one of the things that I personally learned in working on this report was not only the power, but also the flexibility and versatility of the right to healthy environment as a tool, as a legal tool to protect the environment and the more than human world and the human world. And by that, I mean precisely what Melina said in terms of addressing not only the climate emergency, which has received for very good reasons a lot of attention, but also pollution, which is something that Astrid already spoke eloquently about, so I won't say anything more about that. And I'll say something about the third pillar in that triple planetary crisis framework that Melina mentioned, which is biodiversity. And this is a great time to talk about this because, of course, we're gearing up for the biodiversity COP in Colombia in just a few weeks. It's great to see that biodiversity now is getting the type of media attention that climate has gotten over the years, because in the end, this is about the protection of life on Earth. This is what biodiversity is all about. And the right to a healthy environment as a tool, both now with international recognition, but also for many decades now at the domestic level, has been the right that's been most frequently invoked in rights-based biodiversity litigation and jurisprudence. David and I published a paper in Transnational Environmental Law on biodiversity and human rights. And it was not an exhaustive study. We focused on 49 cases from around the world and try to distill trends and insights from that sample of cases. And a couple of things that we concluded is that there is not enough attention being paid to the potential of the right to health environment and other rights-based tools when it comes to addressing biodiversity loss. So we don't have anything like agenda in the realm of rights-based biodiversity litigation and jurisprudence. So for those of you who are interested in bringing interesting new cases to the courts, that's a gap that's worth addressing. And at the same time, we concluded that the two decades of experience on rights-based climate litigation and jurisprudence offers some interesting lessons in how to collaborate with scientists, how to frame the messages of the lawsuits, and then in the case of some courts of their own decisions. So this is an interesting, fascinating, both scholarly and practical gap where the right to health environment can be a potential means to advance biodiversity litigation. I'll end by referring to one specific case. I won't go into the details of that case because our time is limited, but I'm here in Brasilia, just coming out of an event with the Supreme Court of Brazil on climate and human rights structural litigation. And I was very inspired to see the level of interest and knowledge on all things at the intersection of human rights and the environmental crisis. And this is one of the reasons why I want to highlight one of the cases that we included in the report, which is the Brazil Climate Fund case, even though which was a decision handed down a couple of years ago by the Supremo Tribunal Federal, the Constitutional Court of Brazil for all practical purposes. And although it was a ruling on climate that basically in very in very simple terms, this is, I'm going to describe it in very high-level terms, it mandated that the government at that time, the Bolsonaro government, use effectively the resources that it had to advance climate action mostly in the Amazon region. But importantly, from a doctrinal point of view, it framed environmental treaties, specifically the Paris Treaty, the Paris Agreement, as a human rights agreement. And that's a major legal contribution, because it very effectively framed environmental challenges as human rights challenges. And this, I would argue, this is something that the court did not say, but that I would argue expands and extends to the biodiversity loss emergency. So this is high time for using the right to a healthy environment in future cases on biodiversity.
Thank you so much, César. And so, okay, we have talked, and Astrid also walked us through, and César as well, a number of really exciting developments on the right to healthy environment. That is from La Oroya, where we see again the culmination of a number of trends, and the Inter-American Court building on its own advisory opinion, which is also significant and should be mentioned. And as César and Astrid mentioned, we have a clarifying and a growing conversation between the substantive elements on the right to a healthy environment. We also have the importance of increased recognition of certain victim status, right? That is particular victims or communities, as Astrid mentioned, sacrifice zones. And also an increase in affirmation of the obligations of states, both when it comes to their own responsibilities, but also corporate accountability. So that's all very exciting, but to turn it to a less exciting note, perhaps, we'll turn to Michelle. So Michelle, let's turn to a not so positive, but nonetheless very significant case on the right. That's the Greenpeace Nordic Association versus the Ministry of Petroleum and Energy, known as People versus Arctic Oil, a Norway case handed in 2020. In this case, Greenpeace, your organization, and Young Friends of the Earth Norway challenged Norway's decision to issue new licenses for oil and gas exploration in the Arctic Ocean. Greenpeace and Friends of the Earth argued that issuing these licenses violated the right to healthy environment enshrined in Article 112 of Norway's constitution. So Michelle, what position did the government and also ultimately the Supreme Court take? And how have practitioners like Greenpeace and other Norwegian courts responded so far?
Well, thanks so much for having me in this very interesting chat. I am frantically taking notes, absorbing everything that is being said. So thank you so much for the opportunity to be here. And I would first start with, unfortunately and realistically, a lot of times courts don't rule the way we want them to. And the plans that we have to protect people and the environment don't go exactly as we had envisioned, but we always have to have a contingency plan and have victories for the affected communities and for campaigns that are independent of the legal outcome. So while I would agree with the not so positive framing of the 2020 Supreme Court judgment, I would disagree with the not exciting, because it is, and I will tell you why. And just to kind of start a little bit backwards, when that judgment came down, 2020 wasn't the best year, I think, for most of us. And it was December also, and it was the pandemic. And the judgment comes down where the Supreme Court says, the right to a healthy environment, moi. And I will tell you more details, of course, on the actual language that the court used, but found myself being really personally affected by this, because I was like, oh my God, did we do the right thing? Did we go, it's a big gamble, right? Of course, you do your assessments, you talk to allies, you build the best case possible, but a Supreme Court holding what it held, and I will tell you in a minute what that is, what can we do? And my boss, our general counsel, Kristen, we're virtual, so she didn't do this, but I almost imagine like she held me by the shoulders virtually, and she was like, make some lemonade. Find the way to turn these lemons into lemonade. And so now I will tell you the story of the recipe of how we made lemonade here. It all started in 2014 when the constitution in Norway was changed and the Article 112 was adjusted, the right to a healthy environment, and it was put under the human rights section of the Norwegian constitution. And the environmentalists and the youth movement in Norway wanted to challenge what David Boyd actually coined the Norwegian paradox, being very green at home and financing green projects abroad with the money that is made from expansion of fossil fuels, extraction and production. So that's the Norwegian paradox. And the environmentalists and the youth movement said, hey, let's challenge this. 2016, we filed a lawsuit. As part of our arguments, we were trying to show, I think David Boyd mentioned it very well, the clarity on content and what the association obligations are of the right to a healthy environment. It was the first time that it was being used in Norway. And we actually used David Boyd's study showing about 90 constitutions that had this right either explicitly or implicitly. Of course, the government fought us every step of the way. In first instance and on appeal, the courts in Norway said, oh, actually, this is a right. And let me tell you that the content of 112 says every person has the right to a healthy environment that is conducive to a right to an environment that is conducive to health. And later on, it says natural resources will be managed with long-term considerations, which will safeguard this right for future generations as well. And at the end, it says the authorities of the state shall take measures for the implementation of these principles. So what do we make of that? The first two levels of court said, hey, there is a right to a healthy environment, but no, the expansion of fossil fuel extraction is not violating this right. So we actually won on the law, but lost a little bit on the findings, on the application of the law, but not the interpretation. Now comes the Supreme Court in 2020, and the Supreme Court in 2020 actually reverses the findings of the lower courts regarding that this is a right that is enshrined in Article 112. And it held that it wasn't exactly a right, but it was also not a principle. It was somewhere in between. And so, the clarification, the content, and the associated obligations, I really love this term, it was just actually as clear as mud. We're like, huh? And, reading the judgment, what does this mean? It says, to be sure, this article contains positive and negative obligations of the state and has legal substance, but it's not enforceable. It's more like a principle that is used to interpret other rights or interpret other action. So reading further along in the judgment, you can see that, there was a big concern from the Supreme Court on justiciability and separation of powers. Now, let me also put it into context, because back then, the whole right to a healthy environment movement was, taking momentum, but it wasn't yet, in the General Assembly, there was no resolution. It was a different world, I think. And I often fantasize about what would have happened if the Supreme Court had to look at this now, but I don't have to fantasize too much because I have good news, which I'm coming to in a minute. I am aware of time. But anyway, the Supreme Court ends up finding that Article 112 can be invoked before the courts when addressing environmental problems where the legislators haven't taken a position. So it's really giving a lot of power to the legislators. And if they haven't taken a position, Article 112 can be used to examine issues by the courts. But actually, if it has considered the matter, then the threshold is going to be very high. The threshold of review is only if the parliament has grossly disregarded its duties. So it should be read as a sort of a safety valve. So when that judgment came down, part of the significant findings of this judgment was that, okay, it's not a right, it's not a principle, but by the way, emissions of combustion, so scope 3 emissions, should be taken into account in the environmental impact assessment. So we should do this, but at the production stage. And this case was about extraction licenses. So, we try to, roll up our sleeves and start thinking about how are we going to further clarify the content of this right, and how are we going to be making some lemonade here. So the opportunity arose in 2023 to file a lawsuit against 3 blocks at the production stage and really show the court, hey, the Supreme Court said you have to look at scope 3 emissions. Now we're at the production stage. What gives? And of course, the government fought us every step of the way, but we had a positive judgment in 2024 in January, the 18th, I believe. And the district court said, hey, you can go ahead and cancel those licenses. They're invalid, granted an injunction because they hadn't taken scope 3 emissions into account, and they use Article 112 to, look at the sufficiency of government action, or rather inaction in this case. And they also looked at the considerations of the right to information and the considerations for the rights of children and the right of participation. So all these things that were enshrined in Article 112 were used to give a favorable decision at the production stage against Norwegian oil and gas. Fast forward to, what are we now? October 8th, next week, we have to file additional observations because now the case is on appeal, but the question has split. Now the part of the case is at the domestic court in Norway, it's at the Court of Appeal, but the question of scope 3 emissions has now, by motion of the state, been kicked up to the EFTA court, the European Free Trade Area Court. And this is a court akin to the Court of Justice of the European Union, but it's only for Norway, Liechtenstein, and Iceland. And it actually is applying EU law and the case law and the jurisprudence of the Court of Justice of the European Union. So what happens here at the EFTA court deciding on scope 3 emissions is going to have a little bit of an impact, or a lot of it of an impact in the rest of the region. And what does this mean for the right to a healthy environment? Once that EFTA court says, hey, you have to look at scope 3 emissions, then you can use the right to a healthy environment to say, this is the standard. It's not respecting this principle between principle and right. Let's go ahead and continue on, incentivizing Norway to stop the expansion of fossil fuels extraction and production in order to meet their obligations and respect the human rights. Yeah. So I could go on forever, by the way, but I feel like I'm gonna stop here.
No, of course, that's great. It shows quite a bit of passion. And I think that's a great and wonderful story. I think it shows not only that the right itself is very adaptable, but the way in which petitioners can, strategically play with the right and different parts of cases, different stages of cases, and different dimensions of the triple planetary crisis to advance the right and its impact on the ground. So thank you for that great story. And again, I encourage people to ask questions in the Q&A that you might have. So going back to Astrid, now that we have assessed some of the largest and more interesting cases, and we know a bit better where we stand with the right, let's look a bit into the future. So Astrid, from your perspective as the current UN Special Rapporteur, what do you see the role of the rapporteurship in the development of right to healthy environment jurisprudence? You already mentioned David's efforts on sacrifice zones, which I think has been really integral and which has been widely cited in many of the cases that we feature in the report and others as well. So can you tell us a bit more what the conversation between the rapporteurship and courts look like? And could you also maybe give us a peek into some of the priorities of the current mandate?
Thank you very much, Melina, and sure. So from the mandate, one of the main priorities that I'm working on, and you can see that in the first report that it was recently published, and I will present it literally in 10 days at the UN General Assembly in New York, is implementation. In the first report, what I did was summarize the status today of the right to a healthy environment, including as we already have heard, and today it's 85% of UN states have already recognized the right, as also you mentioned, Melina, this at the beginning of the webinar. And so the next step, of course, is implementation, and the role of courts is key, not only to deliver these decisions, but most importantly, to apply and make sure that the changes are seen in the ground. And this is something that I will be working very hard during my mandate. As we heard also from Michelle, and it's a little bit what I also wanted to tell you about La Oroya. These litigations are not one single case, not even if it's one or not. The complexities, and César mentioned that too, it's very complex. And I will also allow to disagree a little bit with this idea of not having decisions from biodiversity. We have a lot of decisions since the 90s. There is a great decisions from Costa Rica, for example, on the Lapa Verde protection, using the right to healthy environment from the 90s, and marine protecting of marine turtles also in Costa Rica, or a Paramos decision for protecting Paramos in 2016. That was key because the Constitutional Court mentioned the Paris Agreement months after it was signed, but it was like the decision was in February and the Paris Agreement was signed in December 15th. So it shows also the possibility of judges to incorporate and be updated about what is happening and deliver decisions that can be implemented in the ground. So that will be key and something that I will be working on. As we also have heard, the right to a healthy environment covers literally everything under the sun. Ecosystems, clean air, safe climate, safe and sufficient water, healthy and sustainable food, non-toxic environments to live, work, study, and play, and healthy biodiversity and ecosystems. And fortunately, I am one mandate, of course, that is encompassing a lot of these elements. And there are other rapporteurs working on climate change, toxics, water, access to justice, information, and participation as well. So I will be focusing mostly on the intersectionalities and the differentiated impacts, so help states and other actors to understand these differentiated impacts, and also identify, and I would love to have a lot of support, of course, from a lot of you working on this. And I mean, I know that this area has a lot of actors to identify solutions, because of course we talk about marginalized communities, but there are a lot of solutions that Indigenous peoples, women, youth, children, elderly, and of course the Clima Señorinen is a great example of those solutions that we are seeing. So identifying solutions will be key. And in terms of substance, my next report is going to be on oceans and human rights. So far, we haven't seen a report from special procedures linking oceans from the perspective of human rights. And this is something that I will be working on, both because it's very important to remind ourselves that oceans, of course, and the depletion of oceans and the threats are linking to the human right to a healthy environment and our human rights perspective, but also because we need also states to implement precautionary principle in a lot of actions, including, of course, deep sea mining. So that is something that I'm working on, and I really look forward to receive your inputs, hopefully, because the call for inputs is already open, and I will be finishing that report in December to present it in March. Then I will also work on clean air, because advancing standards, David did an amazing report in 2019 with recommendations, and we need to continue advancing this and making sure that these recommendations and standards are actually implemented. And then I will be working on clarifying and advancing standards for environmental impact assessments and strategic impact assessments, and also planning, land planning, ocean planning from the human rights perspective. And then advancing standards for access to information, public participation, and access to justice linked to the human right to a healthy environment. We have Aarhus, we have Escazú, there are other regions talking about these elements. So from the mandate helping to implement this. And then environmental defenders is also a key aspect that I will be working through communications, country visits in the reports, but I also would like to prepare a report specifically about what standards and how measures can be implemented, specifically also talking about differentiated and intersectionality. So this talks about the differentiated situations and collective measures, because and the Inter-American system has already mentioned that, and a lot of constitutions, mostly in the Global South, the right to a healthy environment is both an individual element and a collective one. So I will just leave it there because I would love questions and also to hear, but this is in a nutshell, the planet, the idea for the mandate that, of course, I'm very privileged to be having the David and Don as predecessors, because this mandate has already a very, very solid grounds to be able to advance the implementation that we need.
Thank you, Astrid. And that's great. It's great to hear your conversations about oceans, but also about urban dimensions that you actually mentioned with La Oroya. I think these are topics that are up and coming, and we can also see them reflected not only jurisprudence, but also in, for example, the COP negotiations, right, which are very much focusing around those topics. So thank you for that reminder. Okay, so now back to David. David, in addition to all of these exciting opportunities that we have seen and spoken about as we move into 2025. What have you observed are some more general trends in environmental regulation and rights-based decisions at a global level that you think are going to be quite relevant for the right to health environment now and in the coming years?
Yeah, thanks. I've learned so much listening to my colleagues. This has been super educational. And I think I'd like to highlight three things that are kind of trends that we didn't see coming. So these are kind of unexpected surprises, if you will. The first is, and all of these have to be understood in the context of, as you mentioned, the triple planetary crisis. I mean, we have never been at a place of such severity in terms of sabotaging the life support systems of this planet, whether that be climate or biodiversity or toxicity. And so that backdrop is really a critical part of these three surprising trends that I'm going to mention. The first is that obviously in a triple planetary crisis, every government in the world needs to enact and enforce stronger climate and environmental laws and policies. And so as governments are doing that around the world, what's happening is that businesses and industries are filing lawsuits challenging those stronger climate and environmental regulations. And the surprise is that those governments are using the right to a healthy environment as a shield against those industry lawsuits, saying that they are simply fulfilling their human rights obligations by passing stronger laws and policies. So for example, in Mexico, in India, in Kenya, governments have brought in regulations around plastic pollution. Those regulations have been challenged by plastic bag manufacturers and plastics corporations. And the governments have said, well, wait a second, we're just doing our job here. We're fulfilling the right to a healthy environment. And it's very positive that in those cases, courts have upheld those plastics regulations, saying that the governments are justified in taking action to protect the right to a healthy environment. There's also cases involving used vehicle imports into Peru, regulations that were challenged by importers, a nature protection law in Argentina. And so this is really an encouraging trend. The second trend that I'd like to highlight, it has to do with the balancing of rights. And we always talk about, courts have this difficult task of balancing competing rights. But in the context of a world on fire, courts are saying now that when that balancing takes place, in many instances, the right to a clean, healthy, and sustainable environment has to be seen as paramount over other rights. So for example, cases in Panama involving open pit mining, Mexico involving tourism development, the highest courts in those countries have said that while rights do have to be balanced, in this context of a planetary crisis, the right to a healthy environment has to take precedence. So that's another very encouraging trend. And the third trend I have for you is both disturbing and encouraging. And that is that around the world, we are seeing many cases based on the right to a healthy environment being brought by children and youth. And so it's disturbing to me that we are in a situation where children have to, instead of playing football or playing on the streets, they have to actually dedicate some of their time and energy to fighting against this planetary crisis. But those children and young people bringing cases, bringing climate cases, bringing biodiversity cases, and winning those cases in Colombia and around the world, that's an extraordinary thing. And the final point I'll make, which builds on things that Astrid, Cesar, and Michelle have said, is the implementation of these court decisions is really critically important. And so focusing on implementation, for example, in a number of cases involving these horrible sacrifice zones around the world, in the Philippines, in Peru, in South Africa, in Chile, in Argentina, in a number of cases where progress has been made in cleaning up those horrible polluted places, for example, in Manila Bay in the Philippines or in Quintero Puchuncaví in Chile, what's happened is that communities and litigators have had to go back to court a second time, a third time, in order to get the court to take stricter steps to hold governments accountable. And so, using extraordinary remedies such as continuing mandamus, or having a court that's assigned to oversee the implementation of a court order, there are steps that can be taken to make sure that these aren't just words on paper, but these court orders that we're so excited about from a legal perspective also bring tangible and meaningful change to people's lives. So I think it's a terrifically important and exciting time. It's great to celebrate the 3rd anniversary of the Human Rights Council resolution, and we still have a lot of work to do.
Thank you so much, David. So Michelle, briefly, because I know that we're out of time and I do want to make sure we get to the questions. So what do you make of some of these trends that David mentioned? How do you think an organization like Greenpeace will set its priorities in terms of the right to healthy environment in the coming years?
No, thanks so much. Yes, I'm aware of time, but I want to say that, like you said, Melina, that it's a very malleable, but also very powerful tool, the right to a healthy environment. So I see the Greenpeace organizations around the world and working together with allies and affected communities to both use this right standalone, but also in combination with developing jurisprudence for the responsibility of states and also the horizontal application to business enterprises. And of course, we're going to see, just to give you an example, the ITLO's advisory opinion saying that greenhouse gas emissions are marine pollution. How do you use that finding with the right to a healthy environment, for example, in bringing forward further biodiversity and climate combination litigation in different jurisdictions? So things like that, like how do you, not one or the other, but how do you find a way to work together in order to bring litigation that protects the right to a healthy environment, but as Astrid was saying, also has a concern with an intersectional, hopefully decolonialist approach, and looks at differentiated impacts and looks also at supporting vulnerably situated persons in their own pursuit of justice and their own vision of justice as well. So I think that that's going to be our focus in the coming years. And of course, joining these spaces, joining the conversation, because I do think that from these kinds of conversations, we can also help support, help inspire, and also ourselves be inspired as how to use and how to give life to the right to a healthy environment.
Thank you, Michelle. And now lastly, turning it to César. So César, what do you think in our fight to make the right to a healthy environment a reality on the ground? What do you think the role can be for a tool like the Right to a Healthy Environment Toolkit, which is a database which analyzes both legislation and also case law?
Thanks, Melina. I do want to keep to time because your Q&A is the section that usually gets shaved off of events. So the one thing that I'll say about the toolkit is that it's done in collaboration with UNEP, the UN Environmental Environment Program, and it was meant to be a companion, so to speak, to the Saving Center's climate jurisprudence database, which is widely known and for very good reasons. So we're trying to do something similar for the right to a healthy environment, because the right to a healthy environment, of course, is a much more diverse tool. There are many more cases that are rights-based that deal with the environment at large than there are with regards to climate specifically. So there is no way that we can be comprehensive. We don't have all of the cases that are based on the right to healthy environment, but we do make a lot of effort at being mindful of the most interesting and more helpful developments in the jurisprudence. And we're going to continue to publish periodic reports, one coming up with UNEP, together with the updating of the website. Last thing I'll say, because one of the questions, I will transition to the questions, is already about the point of biodiversity. I hope that it was clear that David and my paper does not argue that there are no biodiversity cases that are based on human rights. In fact, by definition, the methodology was designed to capture almost 50 of such cases. So definitely there are worthwhile efforts both by advocates and by courts. What we didn't find is the sort of a sustained trend initiated by landmark cases like Agenda in the climate space that explicitly and over time in a sustained manner frame biodiversity as a human rights issue, leveraging international and domestic frameworks and doing what the question is asking about, which is using goals, specific metrics to hold governments accountable to biodiversity action as they have been held accountable to the NDC's National Determined Contributions on Climate. Luckily, now we have the 30 by 30 framework, the plan of action out of the CBD, and we're expecting, and we say that in the paper that David linked to in the chat notes here, that because the biodiversity international framework is becoming more actionable and more detailed, that those details will be used and leveraged by litigants at domestic level to put pressure on their governments and to take these cases to courts in a similar way as climate litigants have done for over 2 decades now.
Thank you, Cesar, and thank you for getting us started on the questions. I see also that David is working hard to answer some of them. So thank you also, David, for answering them on the chat. One question which I think is interesting, and this is an open question for all of you, perhaps Astrid, you might want to comment, but the question about the regional courts. So we see that the Inter-American Court seems to be a little further in terms of what it has said about the right to healthy environment than, for example, the European Court of Human Rights. So can you speak a little bit more about how far these courts are in that?
Sure, thank you. And I mean, in 30 seconds, maybe. So first of all, at the Inter-American system, the right to healthy environment was recognized in the 80s. In the protocol, San Salvador protocol, that was ratified and that entered into force in 99. So we have already in the region a recognition of this right that is also included in today all of the constitutions, including through the Escazú Agreement. That is definitely a difference that we see in Europe, where there is, and hopefully there's currently a process to discuss the recognition of the right to a healthy environment by the Council of Europe that both David and John and a lot of us, including Greenpeace, also have been working on, and me. So we have there the difference between the recognition and not. And so that, of course, makes this, it's one of the elements of this. The other thing, of course, is that in the Americas, and I haven't seen much, and we have talked a lot about that, but I haven't written or published a lot around that. But I'm absolutely certain that the presence of indigenous peoples and Afro-descendant communities and campesinos and other local communities is in the core of the advancement of both the recognition of the right to a healthy environment and a lot of these cases. And of course, like seeing a lot of that, as you know, and we talked about that, the Inter-American system has a lot of decisions linking environment and indigenous peoples. And it's because of their work and movements. And so in that sense, I think that both to continue understanding and also implementing these decisions, I think that exercises like this, the toolkit and the publication is key, and really encouraging to continue advancing this and even producing. And there's a lot of information, for example, in Spanish, but there's a lot of experience and expertise that is not in writing because movements and communities do not write those kinds of experiences. And of course, decolonizing the work and making sure that we work from movement lawyering on strategic litigations, because yes, of course, we have, for example, one case that it's Agenda, but of course, and as we of course know, we don't need a decision from Europe to continue advancing. There are, as you showed also from a lot of these cases in the toolkit, there are a lot of cases from the Americas, the Oposa case in the Philippines, there are cases in South Africa. So I really think that encouraging and using this cases is key, and the lessons that we can also hopefully continue using from the Inter-American system, not only from the Inter-American Court, but also from Supreme Courts in different countries in Latin America, key in Colombia, Argentina, Costa Rica, Brazil, Chile. There are a lot of cases that can be used as key elements to be implementing.
Wonderful. Thank you so much. And that's a great global review of the right to healthy environment. So thank you, Astrid. And I look forward to your up and coming work. So I'll stop there just because to respect everyone's time. Thank you again, everyone, and David, for answering some of the questions. I encourage you to, if you have any of these questions, to write us to our new email, which is r2he@nyu.edu. This is an email where you can write us any questions that you may have, but also any suggestions that you may have for the toolkit. If you would like to see a case from your own state or another state be put on the toolkit and analyzed. And also to get in touch with us. So thank you so much, everyone, for being here, the audience, and these excellent panelists we've had today, as well as Emma and Anne, their research assistants, for all their support. Thank you. Thank you, Emma, for putting that on there. Bye.